Welcome once again to Know Your Rights University in association with Natural S Compact LLC. We are back at you once again with a video speaking on the beginning of trust. Let us share our screen. The beginning of trust. What is a trust? A trust is a fiduciary and equitable relationship lawfully formed when one person, the grantor or settler, conveys title, legal, equitable, or both, to another, the trustee, for the benefit of a third party, the beneficiary, under enforceable terms and conditions defined by the trust instrument and subject to the fiduciary obligations recognized by law or established by contract. What does fiduciary mean? Black's Law Dictionary, 10th edition. A fiduciary is a person or entity that is entrusted to act for the benefit of another in matters within the scope of their relationship. The fiduciary has a duty to act with utmost good faith, loyalty, and full disclosure toward the principal or beneficiary, and must not seek personal gain from their position. In the case of North Carolina Department of Revenue versus the Kimberly Rice Kasner 1992 Family Trust, we read, in its simplest form, a trust is created when one person, a settler or grantor, transfers property to a third party, a trustee, to administer for the benefit of another, a beneficiary. The trust comprises the separate interests of the beneficiary who has an equitable interest in the trust property, and the trustee who has a legal interest in that property. In some contexts, however, trusts can be treated as if the trust itself has a separate existence from its constituent parts. Interest, as defined in Black's Law Dictionary, 5th edition, means the most general term that can be employed to denote a right, claim, title, or legal share in something. In its application to lands or things real, it is frequently used in connection with the terms estate, right, and title. More particularly, it means a right to have the advantage accruing from anything, any right in the nature of property, but less than title. The trust property is sometimes called the trust res, the corpus, the subject or subject matter of the trust. Property, as was said in Braceville Coal Company versus the People, property in its broader sense is not the physical thing which may be the subject of ownership, but it is the right of dominion, possession, and power of disposition which may be acquired over it. And the right of property preserved by the Constitution is the right not only to possess and enjoy it, but also to acquire it in any lawful mode or by following any lawful industrial pursuit, which the citizen, in the exercise of the liberty guaranteed, may choose to adopt. Labor is the primary foundation of all wealth. The property which each one has in his own labor is the common heritage, and as an incident to the right to acquire other property, the liberty to enter into contracts by which labor may be employed in such a way as the laborer shall deem most beneficial, and of others to employ such labor is necessarily included in the constitutional guarantee. Origin of uses and trusts, from Handbook of the Law of Trust. Trusts, in their early development in England, were divided into two classes, namely special or active trusts and general, simple or passive trusts. The latter were generally called uses. Prior to 1535, Uses constituted by far the more important class of trusts. Uses were introduced into England shortly after the Norman Conquest, 1066 AD. They were patterned after the German Treuhand or Salmon. The principal objects of their introduction were A. To avoid the burdens of holding the legal title to land, such as the rights of the lord under feudal tenure, the rights of creditors, and the rights of dower and courtesy. B. To enable religious houses to obtain the profits of land, notwithstanding the Mortmain Acts, laws to restrict corporations, particularly religious and charitable ones, from acquiring land in perpetuity. To secure greater freedom in conveying land inter vivos. To obtain power to dispose of real property by will. The use was a trust in which the trustee had no active duties, but was merely a receptacle of the legal title for the cesque trust or beneficiary. The words use and trust are employed as synonyms frequently by writers and judges. However, there is a distinction in their meanings. Prior to the Statute of Uses in 1535, there existed in England a relationship known as a trust. Trusts were of two classes, namely active or special and passive, simple or general. Property for some temporary purpose and with active duties to perform, the trust was called active or special. Thus, if A conveyed land for 10 years to take the profits of the land and apply them to the use of C, B was an active or special trustee. These trusts were comparatively rare prior to the statute of uses, but if the legal title was transferred to one as a permanent holder for the benefit of another, but with no positive duties or care or management, the trust was called general, simple, or passive, or a use. Thus, an enfeoffment of A and his heirs to the use of B and his heirs would create a use or general trust. Origins and classification of trust in English law. A. Special or active trust. Special or active trusts were characterized by the imposition of duties on the trustee. The trustee was required to actively manage or administer the property for the benefit of the cesque trust beneficiary. These trusts emerged under the equitable jurisdiction of the Court of Chancery. B. General, simple, or passive trusts. Uses. Passive trusts, commonly called uses, impose no active duties on the trustee. The trustee merely held legal title, while the equitable title belonged to the beneficiary, who enjoyed the benefit of the property. Before the enactment of 27 Henry VIII, Clause 10, Statute of Uses, 1535, these uses were the predominant form of trust, widely employed for avoiding feudal incidents and enabling landowners to bypass legal restrictions. Primary statutory authority, the Statute of Uses. The Statute of Uses was enacted to curb the widespread use of passive trusts. It provided that the beneficiary of a use would be deemed to hold legal title, effectively collapsing the distinction between legal and equitable ownership in such cases. Statutory text paraphrase, where any person or persons stand seized to the use, confidence, or trust of any other person or persons, then the person or persons entitled to the use shall be deemed in lawful season in possession of the land. Merger doctrine, trust law, from Wikipedia, the free encyclopedia. In trust law, the term doctrine of merger refers to the fusing of legal and equitable title in the event the same person becomes both the sole trustee and sole beneficiary of a trust. In such a case, the trust is sometimes deemed to have terminated, with the result that the beneficiary owns the trust property outright. This eliminated passive uses by transferring legal title to the beneficial holder unless the trust was active and imposed enforceable duties on the trustee. Judicial clarification, Tyrrell versus Tyrrell, 1557. Holdings. The Court of Chancery confirmed that if a trust imposed no duties and the trustee was a mere conduit, the statute of uses would execute the use, vesting full title in the beneficiary. Citation, Tyrrell's case. This structure, active versus passive, remained foundational in Anglo-American trust law and was carried forward into American jurisprudence. The legal distinction between active, special, and passive, general, or use-based trusts, originally developed in English law, became a core principle. Breakdown. 1. This structure refers to the legal classifications of trusts and duties to perform, and passive trusts or uses where the trustee holds title without duties, and the beneficiary receives the benefit directly. 2. Remained foundational means that this classification has been fundamental and enduring in the development of trust law. 3. In Anglo-American trust law means this principle has been central in both English and American legal systems. 4. Was carried forward into American jurisprudence means that U.S. courts and statutes adopted this classification system from English law, and it still influences how American courts interpret and enforce trusts today. Each statement reflects key historical and legal concepts regarding the evolution of trusts or uses in English law. Here's a clear breakdown of their meaning. 1. Uses were far more common than special trusts prior to the statute of uses. This means the passive trust uses, where the trustee held property title but had no active duties, were the dominant form of trust arrangement in England before 1535, when the statute of uses was enacted to eliminate them. 2. By the time of Henry V, they were the rule rather than the exception in landholding. This emphasizes that by the early 15th century, holding land through uses was so widespread in England that it had become standard practice, not a fringe method. 3. Uses and trusts were introduced into England shortly after the Norman conquest. This places the origin of English trusts as early as the 11th century, soon after William the Conqueror established Norman control over England. 4. Recent scholars agree that they were modeled after the German Truhan or Salmon, rather than after the Roman fide commissum. This distinguishes the true historical source of English trusts. While other theories link them to Roman law, modern research shows they more closely resembled the Germanic trust-like arrangements, such as the Truhan, where a property was held by one person for the benefit of another. 5. Under Roman law, it was not possible to give property by will to certain persons. For instance, persons not Roman citizens. Roman law restricted inheritance by will. Some people, such as foreigners, could not receive bequests. 6. It became customary among the Romans to devise property to one capable of taking it, with the request that he deliver it to a devisee who was incompetent to take directly. Romans would bypass these rules by willing property to a legal recipient, the fiduciary, and asking them to pass it on to the real intended recipient who couldn't legally inherit. 7. This was the creation of a fide commissum form of trust. This Roman workaround became known as a fide commissum, which literally means a thing entrusted in good faith. It mirrors the concept of a trust where the legal holder must honor the intent of the testator. 8. The obligation of the devisee to the desired beneficiary was not at first legally enforceable, but later became so. Initially, the fiduciary was not legally bound to follow the testator's request, but over time, Roman courts recognized and enforced this obligation, paralleling the evolution of English equity courts recognizing and enforcing trust. 9. This confidence was analogous in many ways to the English trust or use, but different in that it arose by will only. The fide commissum is similar to an English trust in that it's based on moral obligation termed legal. However, it only applies to wills, testamentary transfers, unlike the English use of trust, which could be inter vivos during life or testamentary. It was said by an English lawyer many years ago that the parents of the trust were fraud and fear, and the court of conscience was its nurse. Certain it is that the reasons for the introduction of uses and trusts were not in all cases honorable. The common law of England attached to the holding of the legal title to land many burdens. As the feudal system prevailed when uses arose, the lord of the land was entitled to a relief or money payment when the land descended to an heir of full age, so a tax, in other words, to the rights of worship and marriage when their heir was a minor, and to aids upon the marriage of a daughter of the Lord, the knighting of his eldest son, or when a lord was held to ransom. These burdens and others of a similar nature fell upon the holder of the legal title. These statements explain the motivations, both strategic and at times unethical, behind the origin and use of trust in medieval England, especially during the feudal era. Here's a precise interpretation. Number one, it was said by an English lawyer many years ago that the parents of the trust were fraud and fear, and the court of conscience was its nurse. This is a metaphorical critique of how trusts developed. Fraud refers to the intentional avoidance of legal duties or feudal obligations by manipulating ownership structures. Fear reflects the people's desire to protect property from confiscation, taxes, or creditors. The court of conscience refers to the court of chancery, which enforce these arrangements not under rigid common law, but under equity, focusing on fairness and conscience. Two, certain it is that the reasons for the introduction of uses and trusts were not in all cases honorable. This admits that many people use trusts to evade legal responsibilities, not always for noble purposes like charity or guardianship. Examples include dodging creditors, hiding assets from heirs or the crown, avoiding military service or taxation. Three, the common law of England attached to the holding of the legal title to land many burdens. At common law, whoever legally owned land had to bear heavy financial and service-based obligations. Four, as the feudal system prevailed when uses arose, the lord of the land was entitled to. Under the feudal system, when land was transferred or inherited, the landholder owed dues to the feudal lord. These included relief, a fee paid when land passed to an adult heir, worship. If the heir was a minor, the lord could control the land and even collect its income. Marriage, the lord could choose or restrict the marriage of an heir, often for political or financial gain. Age, required payments to fund major life events of the lord, such as ransoming the lord, knighting his son, or marrying his daughter. These burdens fell upon the holder of the legal title. The key point: only the legal title holder had to fulfill these obligations. Thus, landowners began transferring legal title to trusted third parties via fees to uses, while keeping beneficial control, a trust to evade feudal duties. In short, trusts emerged as a legal workaround to avoid the economic burdens of feudal landholding, and courts of equity enforced them based on moral grounds, even though their initial use often involved manipulation or evasion. These statements explain how the use of uses, early trusts, enabled landowners in feudal England to evade legal burdens, taxes, penalties, and even creditors by separating legal and equitable ownership. Here's a section by section interpretation. One, by enfeoffing another of the legal title and reserving only the use, the tenant escapes such exactions. Enfeoffing, granting legal title to another person, a feoffee. The original owner kept only the beneficial interest, use, not the legal title. This allowed the owner to avoid the burden tied to legal ownership, feudal dues, inheritance, taxes, etc. Two, the legal ownership was subject to the incidence of tenure, but by vesting the season in two or more fees jointly, the burdens incident to the descent of land were generally avoided. Season equal legal possession. When multiple fees, title holders, were appointed, the legal title didn't descend, inherit, traditionally, because when one died, the others survived. This blocked the triggering of feudal duties like relief upon inheritance, since there was no legal descent to a new heir. Three, upon the commission of certain crimes, the holders of the legal title suffered a forfeiture, which could be avoided by vesting the legal estate in another. If someone committed treason or felony, their land would be forfeited to the crown. By holding only the use and putting the legal title in someone else's name, criminals shielded their property from forfeiture. Four, the common law gave no remedy to a creditor against the interests of a cesque use. Cesque use equals beneficiary under a use, trust. At common law, creditors could only seize legal title, not equitable interest. So debtors hid assets by transferring title to a fiefie and keeping the use for themselves, escaping debt collection. Some dishonest persons escape payment of their debts by transfer of land to a fiefie of uses. Reinforces the prior point, this tactic was used dishonestly to avoid paying lawful debts. 6. The incidence of dower and courtesy attached only to the legal estate. Dower equal widow's life interest in husband's land. Courtesy, widower's life interest in wife's land. Since these attached only to legal title, a person could defeat the spouse's claim by holding the land in trust. 7. A husband desiring to prevent the attaching of a dower interest could convey to a fiefie to uses. Men use trust to disinherit future wives by removing their dower rights. 8. A corresponding fraud could be worked by a wife with respect to her husband's estate by the courtesy of the law. Similarly, a wife could prevent her husband from claiming a courtesy right by using a trust. Summary: these statements describe how the early English trust use was employed to avoid legal duties, financial liabilities, marital property rights, and criminal penalties, often through manipulative or fraudulent transfers of legal title while retaining the beneficial interest. Our understanding in today's world from our study of trust law is that the modern trust used today by private individuals is for the effective planning of your estates by means of trust to run your family as a business, providing for their health and education generations into the future, controlling the future of your children and their children's children from the grave, fulfilling the prophecy in the Bible in Proverbs 13:2, which states, "A good man leaves an inheritance for their children's children, but a sinner is stored up for the righteous." To learn more about how you can provide for your children's children long after your passing away by means of a private trust, email us at info@naturalessencellc.com or call 708-539-9201. We thank you once again for tuning in to Know Your Rights University in association with Natural Essence Compact LLC. And until next time, peace and blessings to you all. Thank you.